Коллеги, добрый день.
Dear
Мы
colleagues, good
продолжаем с
afternoon.
вами нашу работу в рамках
Let's continue our
форума
work
РУСАДА.
as a part of the
И
RUSADA forum.
вторая половина дня пятницы мы
And it's
посвятим
Friday
ее
afternoon, and we are going
правам
to
и
dedicate this
обязательствам
roundtable
в
to
спорте в
rights
условиях
and
новой
obligations in
реальности.
sports in
Когда
today's
Вероника Владимировна
reality.
обратилась
When
обратилась с
Veronika
просьбой
Loginova
и предложением провести
asked
форум,
me
я
to
сразу сказала,
organize
что
this
форум будем
forum,
проводить, если
I
будет
told her
правовая
immediately
секция.
that we will only
Потому что
hold this
в
forum
рамках
as long
ГИМО
as there is a
очень большое
session
внимание
dedicated to
уделяется
sports law.
именно правовой составляющей, помимо
The
тех
thing is
программ, о
that
которых
at
вам
MGIMO
вчера уже
University, we
говорили на
do pay a
открытии,
lot of
но
attention
могу сказать,
to
что
the issues of
желаем
rights
людей
and
меньше, чуть
obligations
меньше. 8 лет
in
назад
legal terms.
МГИМО
Because
выступила
around
с
8 years
инициативой
ago, MGIMO University came up with an
разработать
initiative to
специальный курс
work
«Права и
out a
обязательства
special
в спорте»
course
на
on rights and obligations in sports.
площадке Help
And that
Совета Европы.
course would be based on the
И
help
тогда
platform of the Council of Europe.
нам пришлось убеждать даже
Back
функционеров
then, we
Совета
even
Европы в том,
had
что эта
to try and
тематика
persuade the
должна
officials of the
рассматриваться
Council
с
of
точки
Europe.
зрения
And the point we
защиты
were trying
прав.
to make is that this topic should be regarded
И
from
нам
the
удалось
angle of rights
убедить
and protection of
ответственных
athletes'
сотрудников,
rights.
в том
So
числе
we
Михаила
actually
Борисовича Лавро,
managed
который
to
на тот
convince
момент
the
работал в
responsible
Совете Европы.
officials, including Mr.
Была
Mikhail
создана
Lobov,
специальная
who was
группа
working at the Council of Europe
из
at the time.
специалистов,
So
в
there
том
was a
числе
special group established,
представителей
and that
российских
group
вузов.
included
Часть из них здесь сегодня
some
присутствует.
representatives of
В эту группу
Russian
были включены не
universities.
только
Some of them are present
юристы
here today.
МГИМО, но также
And
и
it did not only
МГУА,
include
и, безусловно,
lawyers from
Ассоциация
GIMO
юристов
University,
России.
but
Сергей
also
Викторович Алексеев
Moscow
принимал
State
участие в этой
Law
работе.
Academy,
И
and
мы
in
сделали
particular, the
онлайн-курс. Сегодня
famous
этот
Russian
онлайн-курс
lawyer Dr.
доступен.
Alexeyev took
Российская
part in
делегация вышла из
that
Совета Европы.
work.
Соответствующее
However, by
уведомление было
that
направлено
time,
министром иностранных
when
дел
the course
Российской
was
Федерации
finished,
15 марта
Russia had
2022 года.
withdrawn
Но
from the Council of
это не
Europe.
означает, что
However,
все те
this does not
наработки,
mean
которые
that
были
the course program that
сделаны,
we had elaborated
должны
should
лежать
essentially vanish,
в дальнем углу,
and it should not
самого
be
нижнего
put on the
ящика.
back burner, so
Как
to
раз
speak.
все, что касается спорта, мы
So
сегодня поговорим. Все
whatever,
международные
when it comes
площадки
to
нам продолжают
sport,
уделять внимание.
obviously
И
most
более
of the
того, мы,
international
безусловно,
platforms
должны
continue
ими
to be
пользоваться.
available for
Поэтому
us
без
for debate, and we should
данной
obviously
секции, мне
make use
казалось,
of
что
them.
форум РУСАДА был бы неполноценен.
And I believe
И
that the
здесь я бы
RUSADA forum
хотела процитировать пятый принцип
would have missed
Олимпизма.
out
Это
on a
гласит, что
lot
понимая,
without
что
our
спорт
session.
функционирует
And
в
the
рамках
fifth
общества с
Olympic
активной
principle
организацией,
is that
внутри олимпийского
sports
движения должны иметь
functions
права и
as
обязательства
a part of
свойственные
the Olympic
автономным
movement.
организациям,
Hence, it
включая в себя
should
независимое
have
создание
rights and
спортивных правил и
commitments
контроль над ними,
of
определение
which
структуры
work
и
for
руководства своими
autonomous
организациями,
organizations.
соблюдение права
And it
на
should have
проведение
a
выборов,
clear-cut
свободных от
structure. It
любого
should have the
внешнего
rights to
воздействия,
hold
а также
elections which
ответственность
are
за
free from any
обеспечение
external
применения
pressure, and
принципов
they should also
добросовестного
be
управления.
responsible for
Как вы видите, здесь
ensuring the
также
principles of
в
responsible
пятом принципе
government.
олимпизма
In this fifth
речь
principle,
идет о правах и обязательствах.
we are also
Поэтому
talking
я бы
about
хотела
rights
открыть нашу
and
сессию и
obligations. So I would
передать
like
слово
to start
крупному
today's
специалисту в этой
session
сфере, председателю
by
комиссии
giving
по
the
спортивному
floor
праву
to head of the
Ассоциации
Commission
юристов
for
России,
Sports Law of
в ходе
Russia,
которой
Russian Lawyers
проходит ряд
Association,
мероприятий, которые
which
особо уделяет
organizes
внимание,
many
безусловно,
events
защите
in
прав
sport law, and it
в
pays a
области
lot of
спорта.
attention to
Сергей Викторович
protection of
Алексеевич,
rights in
большому труду,
sports.
как я уже
And
говорила,
this is
соавтору
going to be
курса
Dr.
и
Sergey
участнику всех
Alexeyev,
наших национальных
whom I have
мероприятий
already
спортивных
mentioned.
и
He is a co-author of the
большому
course I was
патриоту
talking
этого
about.
направления.
And please,
Спасибо
you
большое,
have the floor,
уважаемая
Dr.
Тамара
Alexeyev.
Викторовна, уважаемые коллеги.
Thank you very much, Dr.
Имею честь вас
Shashikhina. Dear
приветствовать
colleagues,
Центральной
esteemed
юридической
guests,
организации нашей страны,
let me
Ассоциации
welcome
юристов
you
Российской
and
Федерации
greet you on
в
behalf
стенах
of
этого
the Russian Lawyers
центрального международного
Association. And here at MGIMO University, which specializes in international relations and sports law in particular as well. And since we're talking about sport law, I'm going to say just a few words and give you a brief idea of how sports law has been developing in Russia. When it comes to academic research in terms of sports law, it has been around for some 22 years. Initially, people did not really see this kind of branch of law as a standalone and as an independent branch of law. However, in the early 21st century, a lot of scandals started emerging in terms of sports internationally. And, the sports management was also suffering during the 1990s half-baked reforms. And this obviously had an impact on organization of sporting events and the sporting bodies themselves. So there was an overarching crisis, and in order to overcome this crisis in Russia, what we had to do was bring together all of this body of law that was available. And we had to supply some academic grounds and support with research all those principles that we were postulating. So when we had this Olympics contests in Salt Lake City and in Brisbane in Australia, we were actually in dire need of sports lawyers, but there were none in our country at that time. So we understand that this encouraged the development of sports law in Russia. Thanks to Pavel Krasheninnikov, who is a famous lawyer in Russia, and Irina Viner, head coach for the Russian national team of gymnasts. We have been able to publish a number of books on sports law, and there is a whole course, a whole set of course books. Here are some of them. And then Russia started training sports lawyers in various universities, and our graduates have already occupied some certain high offices in terms of sports law. The next stage in terms of development of sports law in Russia had to do with international regulation of sports. This issue was discussed yesterday at the United Nations General Assembly in New York, and a resolution was adopted on sports being an essential factor of peace in the world. And yesterday, I believe that these ideas and principles were very clearly set out by Thomas Bach at a major international forum attended by leaders of all the states, and he said that international Olympic sports and Paralympic sports is a way of mitigating international armed conflicts, because sport has to be neutral, and it should be neutral, and it should not be politically charged, and it should have nothing to do with any political confrontation in today's world. Hence, a ban on discrimination in terms of any athletes, whatever country they come from, even if that country is involved in a military conflict. So we proceed from the assumption that sports brings together people of different countries and athletes from different countries. And the subjects of this process are the athletes themselves rather than federations or organizations. And the athlete does have a whole range of rights, including the right to fair access to participating in international competitions. Discrimination based on nationality should also be prohibited. Because if you start dividing people into first class and second class citizens, depending on the state that they live in, this is a blatant case of discrimination and violation of criminal law, especially when people use their own resources and their own leverage in order to discriminate against athletes. This is, of course, unacceptable in any given country, and the supremacy of law is a #1 priority in Europe. And then when there are some cases of unfair competition, like Belarus and Russia, when Belarus and Russia have some athletes who are actually the most competitive in certain sports, and then those athletes are actually expelled from the game. This is absolutely, again, this is absolutely unacceptable. The next stage had to do with the Russian Olympic Games in Sochi, and there was a new track of research, the Olympic law, so-called Olympic sports law. This is a unique book that was written by Thomas Bach, and even Russian President Vladimir Putin has this book in his library in the Kremlin. The next stage of research and of development in Russian sports law, it had to do with it was a phenomenon that was connected with the World Cup. So Russia obtained the right to organize and host the World Cup in football. And that gave rise to football law in Russia. Gianni Infantino, he got a book, a course book in football law. He was very upset to learn that this great book was not translated into English. And of course, you need to have very solid legal grounds and very solid research and academic books in order to train specialists in this particular field of law. Another issue is labor relations in sports. And in Russia, there is a new field of law, which is called sports labor law.
В едином месте сборники всю нормативную базу, регламентированную для специалистов, руководителей кадровых служб, соответствующих спортивных организаций, руководителей организаций и так далее.
The leaders of the organizations should get acquainted with the law. So the sports labor law is one of the most important areas, which is also becoming an important area of studies in education and other areas. Professor Fedorov has written an article on the topic, and the topic of the article is the sports and criminal labor law. So our school is developing in a very important direction. Sports is an important economic industry. That's why the economic law and marketing law should be applied in Russia, given the Russian context. So we are developing the sports marketing and sports management in Russia, which also contains the international management. Also, we're publishing a number of textbooks with regards to Russia, the sports marketing, sports management. Here you can see this bunch of books. And another important thing, our friends from far and near abroad has got interested in our school and are creating a similar school. And we've just published together with the Belarus the first textbook on the athlete law, and our disciples in Azerbaijan are developing the textbook on the same topic in Azerbaijan. So it's a sort of a chain reaction. Also, the Minister of Sport has given an instruction, a request to create a cycle of textbooks for coaches, doctors, etc. And the Minister of Sports recommends that this sports labor law and its textbooks should be used by them. They should get acquainted with all this information. Of course, it's difficult to seek for separate provisions relating to this law in a national and international law. That's why we've just consolidated these laws in this big book, and you can see this book. It's big. It's labor law. The book about labor law in general, sports law, and thanks. I would like to thank Irina Wiener. It's one of the most the areas of the most demand. And summing up my presentation, coming back to the topic of today's discussion, I'd like to mention normative acts, provisions of the International Olympic Movement, including the Charter, which says that sports and international sports is a means of friendship and participation between athletes of different countries. It's soft power that should build bridges under the circumstances of geopolitical turbulence and military complex that are underway in all parts of the world: Palestine, Israel, not only Russia and Ukraine. Bombs are thrown in Iraq and Syria. That's going on all the time. It's an objective reality, and sports should be out beyond politics, should be independent, neutral, and impartial. And yes, as yesterday Thomas Bach said, that if only the friendly countries participate in competitions, that would put an end to the Olympic movement, because its essence would be undermined. That's why we believe that we should apply these canons proclaimed in the Charter, and for this we need the normative basis, and we need to develop research in this area. So also important thing is to introduce the instruments of sports athletes labor law into the general practice, and they are very important practical issues. And as the labor law is commonly violated, and many rights are violated. For example, the athlete's right to labor, or it's his/her image rights. So we need to pursue the implementation of this law into life. So I'd like to wrap up with concluding remarks that on the eve of the Lawyers' Day, we should make a contribution into making the sport designed to reconcile the parties in the international conflicts. It's just the essence of the sports. It's one of the forces that would be able, would help us, facilitate us to preserve our planet. And Thomas Bach yesterday talked about it, and we would like to greet the resolution taken by the General Assembly, and we hope that it would not not be just a demagogical speech, but it should be introduced into reality and into practice. So on behalf of all the lawyers of the Russian Federation, I'd like to congratulate you on the Day of the Lawyer, on the coming Day of the Lawyer, and I'd like to wish everybody that we would observe, everybody would observe the supremacy of law, and you should be on the side of the law. Thank you very much. Yes, Sergey. The Olympic logo, Citus Altius Fortius, is quite up to the point. And Thomas Bach's words should be in line with the practice, because what he is talking about is quite it has a great importance for us. His ideas are quite sound, and for example, at his sound of G20, he said that we should be politically independent and impartial in sports. And he also talked about the principles of non-discrimination of the athletes. Unfortunately, we cannot ask him personal questions because we're not invited into the roundtables, international roundtables. He might have make some comments. For example, why in autumn 2022 he talks about such sound things, still the suspension of Russian and Belarus athletes are still in place. So words and deeds are absolutely different. So I would just like to ask such a question. As the General Assembly and the G20 are very high roster, so we'd like Mr. Bach get back to his recommendation, because it's still in place, and maybe they would change their attitudes with regards to the Russian and Belarus athletes. I'd like to give floor to Vladimir Zaitsev, the chairman of the disciplinary department of RUSADA. So, disciplinary anti-doping committee of RUSADA. I'd like to say a few words about it. First of all, we'd like to thank Vladimir Zaitsev, because we can see clearly how you are working, and all the representatives of various areas, pharmaceutical industry, doctors, and we have discussed all these issues with the representatives. So it turned out that none of the lawyer, sports lawyer can start a hearing without the support of a doctor. So these two professions go hand in hand, and two experts and specialists communicate with each other, and they defend the rights of an athlete or a team. So Vladimir Vasilyevich, thank you very much for your presence here. Thank you very much, Tamara Viktorovna. I'd like to thank the organizers of the conference to be able to have a chance to talk here. First of all, I'd like to tell you how the disciplinary committee operates, and I'd like to make some general conclusions after 2 years of my involvement in the committee. So there are two important aspects in our work. They are very important and we stick to them. The first aspect is the principles the committee is based on, and they are set forth in the International Anti-Doping Code and in other documents and conventions where signatories to. And the second aspect is the makeup of the committee, which operates in operates with this makeup for more than 2 years. I'd like to talk about specific persons, people who are involved. So Russia has been for a long time a member of WADA, and it coincided with the epoch of reform in Russia with regards to Russian athletes international involvement, and that's why the issue of anti-doping has come to the fore. The most important issue is to protect the rights of athletes to take part in competitions free of doping and to be involved to organize public information campaigns about the need to be healthy and to lead a healthy lifestyle. So these are our principles. We are operating on the basis of the provisions that are approved by the oversight board. So RUSADA sets up the oversight board, and the committee sets the rules. And the committee is organizationally, operationally independent both from RUSADA and from the oversight board, and they cannot influence its decisions. I think it's a basic principle that allows the disciplinary committee to make sound and well-thought decisions and legally binding legal decisions. So all this delineates the competences of the committee of hearing of any case of an athlete. On the basis of these principles of the National Anti-Doping Agency, disregarding the athletic sports agencies, given the interests of a person. So this is the basic principle of the committee's operation. And for example, those who are connected with the state cannot be members of the committee and influence its work. The basic objective of the committee is to provide impartial, independent, and fair hearing and investigation, and taking into account the rights of athletes who are accused of violating the anti-doping legislation. It's with the objective to support clean sport. It's not just empty words. They are propped up by the deeds. So these are principles are the basis of all the activities of our committee. The makeup of the committee. It's the members are selected by the oversight board. The members who are lawyers and who have experience in jurisprudence at least for 5 years can become members. Also, experts from the medical area, from pharmaceutical area with the experience work of at least 5 years as well. The chairman is elected for 1 term. So the members of the committee include 2 doctors of jurisprudence, 1 candidate of medical sciences, and some members also have degrees in law and two are lawyers who practice the law. So the minimal number to investigate is 3 persons. The normal makeup is 5 persons. The procedure is rather democratic. It resembles the court hearing. There are representatives of the athlete, or an athlete himself, herself can talk, can give evidence, can file a complaint, and all the experts are provided with the necessary conditions of work. They give their expert examination during the investigation of the case. So the character, we have an adversarial or contestatory character of hearings. Though not all athletes come with their representatives, because sometimes they do not have money for this. And of course, it affects the decisions, because the athletes themselves sometimes are not unable to present evidence in the right way. And sometimes they just don't say the right things that support his legal position, and nobody can help him. The same is true about the medical expert examinations and conclusions.
At the same time, people very often don't really know how to apply the principles of therapeutic use exemptions, what the rules are, and how to apply them. So part of those violations are only possible because the doctors are even unaware of the use of the list of prohibited substances for athletes. And I believe that we need a training program to educate not only the athletes, but also doctors, medical professionals, and most importantly, sports lawyers, in order to be able to protect the rights and enforce the rights of athletes. That might be a master degree program or some other kind of program, but we definitely need one. Obviously, there is a lot of work being done by RUSADA agency in terms of training and educating the athletes. However, training sports lawyers is a whole different thing, and it is essentially something that we need to work on really hard. Not all the athletes can and are capable of using and resorting to the services of lawyers. So what we need to do is provide for allocations from the budget, just like there are budget allocations for counsel for the defense in criminal proceedings. Just the same thing should be done by the government in terms of athletes. Since the government is in charge of a whole agency, which is RUSADA, I believe that the government may also allocate a certain sum of money to pay for the sports lawyers who will protect the rights of athletes. The number of cases regarded by the anti-doping committee amounted to 66 last year. As of today, there are 43 of those cases. There are still cases that have to be considered. Not all of them have been submitted yet for consideration. However, there is a small reduction in the number of cases that we have been witnessing. Now let's move on to the conclusions that I came to over the 2 years of my work in the Anti-Doping Committee. Obviously, one thing that I'm very concerned about is the appeals procedure. Even though my colleagues from RUSADA have said that this procedure works just fine, it is not really true. So one way to do it is the National Center for Sports, for sports mediation, and the other one is the sports court. So this court, court of arbitration, is if RUSADA, for instance, decides to dispute a certain decision, then it cannot any longer appeal to that arbitration court. And this kind of disputed claim may apply not only to an anti-doping committee, but also to other bodies that may discredit our athletes. If we look at the anti-doping code on a worldwide scale, we will see that it says that every country that follows its rules should set up a standalone individual body for disputing the decisions of the courts. But this is a very important issue that we need to deal with. And there may be a situation where an athlete decides to file a claim, to dispute a claim, or dispute a verdict, but the RUSADA may disagree with that, or vice versa, and that will present a challenge for us. Now, as I was preparing my presentation, these are the conclusions that I have come to in terms of WADA's position in this kind of disciplinary process. If we open the World Anti-Doping Code, we will see that on the one hand, WADA is a creator of rules, but then on the other hand, WADA can also participate in the whole process. So at the same time, WADA creates the rules which it is supposed to abide by at the same time. I think this is something that should be fixed. This situation is not actually the right one. So here is what they say in the code, that anti-doping rules are different from the rules in criminal law and civil law, and that cannot be limited by any kinds of national legislation and standards. All arbitration courts and other bodies that implement various legal rulings must stick to anti-doping rules. So that is to say, all the national courts in Russia and other courts as well must abide by those rules. But then you see, WADA's requirements are not international law and cannot be part of international law. Instead, these are rather corporate rules, I would put it this way. So why does WADA insist on those rules being complied with? So we have a representative here of Justice of the European Court for Human Rights, and he will confirm that the European Court for Human Rights can actually create its own legal norms. And the same here applies to WADA, actually, if you come to think of it. Although this is happening in a quiet way, still, this is an ongoing process. So WADA is like enforcing its guidelines and enforcing its recommendations. But this is a problem in terms of how well it complies with international law, and we need obviously a monitoring body for that, whether that be in the framework of RUSADA or the healthcare ministry, but still, this process has to be followed very closely. We need to look at how WADA recommendations and guidelines impact the application of principles within that code. I'm talking about principles related to the rights of athletes and RUSADA rules and everyone involved. Thank you very much for your attention. Thank you, Dr. Zaitsev. Obviously, the issues that you have raised are extremely relevant, especially when it comes to education for sports lawyers. Unfortunately, not all of the federations have a lawyer of their own, a sports lawyer, and there are federations that still need some lawyers for legal services. They still have to sign contracts. And we find ourselves in a situation when athletes have to prove that they're not guilty, where we do not have this presumption of innocence in sports law. The athlete has to prove himself that he is not guilty of doping or any other violations. And then obviously the athlete has to ask lawyers, other lawyers, and he has to pay fees to them from his own pocket. And then there is the difficulty of finding actually the right professional. And then the conclusion that is to be drawn, perhaps, is that we need to build a pool of professionals in sports law that would be interested in protecting the rights of athletes in sports. And that would also be very relevant for individual athletes, in addition to WADA, the International Olympic Committee, and the national federations. It is very important to ensure those rights in the framework of the international sports and international Olympic movement. And unfortunately, Russia does experience a strong deficit of sports lawyers, even though we do have quite a number of departments that train those professionals. We need some ad hoc measures right now in order to resolve the arising issues. In addition to that, there is the issue of the rules, the procedure that has to be followed. I said this even yesterday when I was talking to my colleagues. I had this issue popping up in my head, even back in the day when I was president of the board. I was asking myself and my colleagues, how can this disciplinary committee be part of the council for the prosecution? Maybe these two things have to be separate. So you cannot have the same structure in charge of the prosecution and passing judgment at the same time. In Switzerland, for example, they have separated these two structures, because this is what the situation that we have. We have prosecution coupled with the body that is supposed to pass the verdict and make the ruling. So this puts the side, the accused, so to speak, the defendant, it puts them in a situation which is not very favorable. And then for that, we also need, obviously, some funding that would be allocated for the legal counsels, for the lawyers that represent the interests of the athletes. I believe that this is an issue that is worth considering in the future. And let's not put this issue on the back burner, because obviously this is very, very relevant for us today. I'm extremely happy that at this session we have been able to bring together almost all the stakeholders who are interested in this way or another in the process, in the sports movement and sports law, including people who usually work for the prosecution and defense, and people who engage both in research and practice in sports law. Now we have an online visitor, an online guest, Arthur Graham. Thank you so much for finding the time for us. He is the representative of RUSADA in the Sports Court of Arbitration. He's also an independent lawyer, and he will speak English. So if you need any translation, please put on your headphones. There are some headphones on the desk in front of you. If you need any translation, you may check out the broadcast online on YouTube. Arthur, are you there?
I am, yes. I am. Can you hear me?
Yeah. Hello. How are you?
Yeah, I'm fantastic. Thank you.
Perfect. The floor is yours.
Thank you. Well, first of all, thank you for inviting me to speak to you today. I feel flattered to be able to speak to such a distinguished group of professionals. I hope that the points that I make in support of the remarks that were made by the preceding distinguished speakers will be of some assistance to the discussion. The broad theme of the conversation relates to athlete rights and the related issue of legal training. And I've prepared some thoughts to offer to you in relation to both of those issues. In relation to athlete rights, the World Anti-Doping Agency has actually tried to draw together some thoughts about the fundamental rights that athletes have in relation to the anti-doping framework. And I'll just wave it around here. It's called the Athletes Anti-Doping Rights Act. And what WADA has done is make a list of rights that they say athletes have in the field of anti-doping, although those rights really reflect the rights that any person would have. They in effect give the context for the rights that sports people have when they participate in sport. And some of these rights are rights that you've mentioned already today. There's the right to education from organizations that have anti-doping authority over them. The right to justice, meaning fair and open hearings in relation to disciplinary matters. And Mr. Zaitsev has just described very, very eloquently and very clearly how that right is given effect in Russia through RUSADA. And the right to be treated fairly as part of an anti-doping program and more broadly. And I guess in that respect, the remarks made by Professor Alexeyev in his piece earlier today resonate there, that athletes have this broad right to be treated fairly as participants in their chosen economic activity. The open question when it comes to this act is whether these are rights that sports people have, or whether they are in fact an expression of the rights that everybody has, and the way that WADA expresses them is explaining how rights that everybody has should be viewed in the context of participating a sporting career. And so I think the value of this instrument is giving some illustration as to how a person's basic rights should be applied in the context of their career as a sports person. And just to give an example from this, the first right is equality of opportunity, which is an issue that Professor Alexeyev spoke to you on at the start of this particular session. The fourth right is a right to justice, which is the issue that Mr. Zaitsev has spoken to you about in relation to athletes' rights. So it's clear that the athletes' rights in this instrument, they're not really athletes' rights, they are people's rights as applied in the context of sport. Now, this instrument is also interesting because it includes what it is referred to or described as recommended rights. So these aren't really fundamental rights. These are extra things that it might be felt are helpful to have in the context of sport and a sports person pursuing their career in the context of the anti-doping framework. And a couple of the interesting rights that are recommended are, first of all, that athletes should have a right to participate at some level in the governance of the organizations that have jurisdiction over them. And this is adopted and implemented in a number of ways, but the most usual way is for athletes to participate in athletes' commissions or athletes' committees, and for those groups to provide advice, opinion, input to the organizations that have jurisdiction over them. And they can be very helpful when it comes to the operational exercise of an anti-doping program. Every athlete is different. Every group of athletes is different. Athletes have specific realities that go with their lives and their careers, and anti-doping organizations understanding those and being able to shape their programs according to those realities to give them the best effect is a very useful feature. And so what the code says is that's something that's helpful to have. The other recommended right is an issue that's been spoken about previously. Mr. Zaitsev mentioned this, which is the right to some form of legal support or legal backup when it comes to the sharp end of the anti-doping framework, which is disciplinary proceedings. Now, most sports people go through their entire sport career without really ever having to worry about the anti-doping framework. The only engagement they have in relation to the anti-doping system is providing urine and blood samples from time to time, and never hearing anything from RUSADA or their federation or any other organization about the results of those samples. But unfortunately, on occasion, things do go wrong, and athletes end up being involved in a disciplinary process that relates to the application of the anti-doping rules. Now, I think we would all agree that the anti-doping rules have not become simpler over time. They've become more complex. The code has got longer, the rule book has got longer, and they are increasingly a challenge to follow, and they present challenges in terms of the disciplinary process when the rules are applied against athletes. And when it comes to some disputes, athletes need expertise and support to guide them through the process. There are a number of ways that this can be provided, and increasingly different organizations are finding different ways to try and address this practical issue. The reference that's been made in remarks already to training and including disciplinary frameworks within a broader sport lawyer training module are very welcome. They're very productive, because that means that more lawyers know the context for the anti-doping rules. There are different initiatives that are run by different organizations in different countries. In Azerbaijan, for example, the setup there involves a pool of voluntary lawyers who are prepared to assist athletes who face disciplinary action to assist them through the process. I think anybody who's been involved in the anti-doping process knows that an experienced and knowledgeable advisor makes the process much simpler and much more straightforward and much fairer for the athlete. The implications of an anti-doping rule violation case for a sports person are daunting, stressful, upsetting, and difficult to deal with for anybody. And having someone to support you through that process, regardless of the circumstances, is a great addition to the process. The follow-up points that I wanted to make in relation to the rights are really, I think, probably twofold. First of all, there's not much value in rights or having rights if you don't know what they are. And that speaks to the issue of education and training for sports people. Russia, like over 190 countries, has adopted the UNESCO Anti-Doping Convention and has committed through the convention to the provision of education to sports people on matters, and I'll just list the things that are referred to in the convention. They include doping control procedures, athletes' rights and responsibilities in relation to anti-doping, the consequences of committing a violation, the list of prohibited substances and methods, therapeutic use exemptions, and the risks associated with using nutritional supplements. So by committing to the convention, Russia, like all the other countries that have committed to the convention, has agreed to provide that education to its sports people. And the way that education requirement is fulfilled is primarily through RUSADA, as the primary agency within Russia tasked with responsibility for fulfilling Russia's commitments under the convention. But the delivery of that commitment obviously can go further through sports organizations, through athlete organizations. In many ways, it's less important as to who the communicator is, as it is to the fact that the communication of the correct, accurate, and up-to-date message takes place. So rights, it's great to have rights, but unless you have education as to the context for the rights themselves become a little less important. I've talked a little about the need to have specialist advisors and specialist people who can assist sports persons. I won't repeat the remarks that were made by Mr. Zaitsev on this. He made the remarks I would make much more clearly and more eloquently than I could, and I thank him for addressing that issue. The one final issue that I sort of offer for discussion is maybe the issue of proportionality when it comes to an athlete's rights. The principle of proportionality, of reasonableness, of fairness is built into the code. And the code recognizes that the rules have been developed having regard to the need for the rules to be proportional and reasonable. Now, every now and then, you will have special situations where the rules don't produce a proportionate outcome. These are rare cases. The start point for this was a tennis player who got into trouble with the anti-doping rules a few years ago and was facing a very long sanction for what was, in fact, a completely innocent violation. And the principle of proportionality was applied in his case by CAS to provide some relief against an otherwise disproportionate sanction being imposed. More recently, I'll offer these two cases by contrast when it comes to proportionality. There was a case involving a professional footballer here in the United Kingdom who tested positive for cocaine. And at the time, the rules were different for cocaine to they are now. And in effect, the minimum sanction anybody could ever get for cocaine was 1 year. In his case, the hearing panel accepted that his use of cocaine was motivated by the player suffering a great deal of psychological distress as a result of a really terrible family tragedy. And so rather than imposing a year's sanction, the hearing panel, applying the principle of proportionality, imposed no sanction, which is contrary to the black letter rules, but is consistent, they said, with the application of the principle of proportionality. Now, in contrast, there was a Peruvian footballer who also tested positive for cocaine ahead of the World Cup in Russia in 2018. I think his name was Guerrero. And initially, FIFA applied a reduction in his sanction to 6 months, again based on the principle of proportionality. But in his case, Cass said that the application of the principle in his case was flawed, and that he should have actually received the sanction that the code mandates. Those cases are interesting because they both involve the application of the principle of proportionality, but they result in different outcomes. One athlete benefited from the application of the principle, and one athlete didn't benefit from the application. And I guess for you in terms of your discussion, the start point is that everybody agrees that proportionality is important, but it's very difficult once you accept that to work out when it should be applied and when it shouldn't be applied, because that decision is always going to be subjective and based on the subjective opinion of the particular hearing panel involved. And different hearing panels will have different opinions about how proportionality should be applied. And so the interesting issue there is, well, whose opinion is more important or more valuable? Is a CAS arbitrator's opinion more valuable simply because that person happens to be a CAS arbitrator? Or is there some broader approach to proportionality that can be made to remove the subjective element of the application? Because one of the aspirations behind the code is to remove subjectivity, to have objectivity, which means that sports people get treated the same everywhere. So I guess that probably brings me to a good place to finish my remarks, which is athletes should be treated the same way everywhere, and they should all have the same rights based on an accepted set of rights that sports people have, regardless of the sport or nation that they choose to compete in. The WADA document refers to that, but really that really speaks to a broader set of accepted rights that we've heard a lot of interesting things about already today. So Tamara, that's all I have to say there. I will pause there and allow the next speaker to proceed. I don't know whether you're going to do questions and answers now or later, but obviously I'm here if there's any remarks. If anybody thinks anything I've said is completely wrong and goes, well, I don't agree. But again, thank you all for your attention, and I very much appreciate both the opportunity to speak to you and also appreciate the courtesy that you've shown to me by allowing me to speak to you in English, because my Russian is
a pleasure for us.
Quite poor. Thank you.
Большое спасибо.
Thank you very much, Arthur, for your very clear presentation and for the review. Thank you for participating in our discussion, and thank you for representing the interests of RUSADA in the present condition. It's a great deal. You just show your independence and impartiality. Unfortunately, under the present circumstances, in a new reality we're going through for several months, it's really very difficult to represent and protect interests of the Russian athletes. And Veronika Viktorovna talked about it yesterday. Even representatives of RUSADA are not invited to international educational roundtables and fora. So just it's beyond reasonable. And we hope that the rational, reasonable approaches will come back to sports and the competition organization. As I already said, the Russian Federation has left the European Court for Human Rights, but it doesn't mean that this area is not important for us. And the example is sports and the protection of athletes' rights. Over a big period of time, there were some doubts or have been doubts about the sports protection in the European Court. But now it's clear that parties can lodge an individual complaints against the decisions taken by specific courts or by the Federal Swiss Tribunal or CAS, which is located in Lausanne. So the issue arises, how can it help to Russian athletes, as there is a principle enshrined in the principle of the Charter and Convention, the principle of territoriality. If athletes' rights are violated on the territory of the country, he or she can appeal to the European Court of Human Rights, and Russian athletes included. If they are not, if they do not agree with the CAS decision, they or the Federal Swiss Tribunal, they can go to the European Court of Human Rights. Today, we do not have examples that show that the rights of Russian athletes are protected. There was an attempt made when an appeal was sent to the European Court on the case of Danilova and Lazutina. But back then, despite the fact that the complaint was acceptable, the party did not take part in the hearing and withdrew its complaint. And our lawyer Kucherena wrote a book on the case where we explained all the details. So at present, we do not have cases that protect the Russian athlete rights. So the time has come to think about it. How can the athlete rights can be protected under the present circumstances when they are violated on the territory of the European Union? So I'd like to give floor to Mikhail Lobov, who has been the court, the judge from in the court. And he has moved through all career ladders in the Council of Europe. He was elected as a judge from the Russian Federation in the European Court for Human Rights, and he is a best acquisition for us, and now he'll work with us at our department. So it just the Mikhail Lobov is the best acquisition 2022. He will share his great experience and expertise with us. So there are not many examples of anti-doping cases in the European Court, but still there are some. And the National Federation of Sports Trade Unions of France and some other federations joined it. Some athletes included more than 100 applications that were considered in Strasbourg. This case is called the fight for human rights by athletes.
Хотя надо очень четко понимать процедуру в данном
The
деле
crusade
отечество выступало не
against
Всемирное
Vado,
антидопинговое
it
агентство,
was called.
а в Европейском суде
So
по правам
the
человека все обвинения
defendant
осуществляются
was
против
not the
государств на территории
Vado,
которого
but
нарушены
the
права
state
спортсменов. Поэтому
where the
ВАДА никак не могло быть
human rights
ответчиком.
of the athletes were
Безусловно,
violated.
речь
So
шла
the
о
Vado
Швейцарии.
could not be a defendant.
Многие
The
интересные
defendant
вопросы
was
были подняты в этом
Switzerland,
деле,
and that
в
case
том
raised
числе
a number
спортсмены
of very interesting
заявляли о том,
questions and
что
issues. For
такие
example,
ограничения,
the
которые
athletes
вводятся в связи с
said
тем, что
that
должны
all these
предоставлять постоянную
restrictions
информацию о месте своего
introduced, such as
нахождения,
they have to give
фактически
information about
напоминают
their location
браслеты,
all the
которые
time,
надеваются
means
заключенным,
that
и они находятся под
they
постоянным контролем.
resemble a
Дело шло в том
situation
числе после его
with
Европейский конвенции по
prisoners
защите прав человека.
which
Это одна из самых
survive prisoners
сложных,
with
наверное, статей
e-bracelets,
и самых
electronic
интересных.
devices of
Не
tracking.
буду отнимать
Okay, so
возможность
there are
рассказать
very many other
опыт
interesting
управления Михаила
issues.
Борисовича.
So I
Борис
think that Mikhail Lobov will talk about all of them.
Спасибо большое.
Thank you very
Тамара
much,
Викторовна.
Tamara Viktorovna,
Ну,
for
и спасибо за
your
добрые слова,
introduction.
прежде всего.
Thank you for your
И-
kind
Михаил
words.
Борисович выпускник МГИМО,
Да, я
поэтому
очень
он
By
не
the
просто
way,
там
Mikhail
комбинации.
is the MGIMO graduate.
Слова с моего
Yes,
языка. Я рад, что
just I was going to talk about
МГИМО
it. I'm
моё,
very glad to come
оно
back to MGIMO.
начинается вот с этого замечательного мероприятия.
And I'm very glad
«Чистый
that
спорт».
my return starts
Очень имел
with
честь
this
закончить
great
Международный
event,
факультет в
our
Швейцарии.
Fights for
Да,
Clean
немного
Sport.
в аспирантуре.
So
на
I
кафедре международного
also
права. И
made
вот
some
теперь
postgraduate
судьба
studies
повернулась так,
at
собственно,
MGIMO,
я
and
тоже
now
считаю это огромным
I've
приобретением
just come
для
back to
себя.
my alma
Вот.
mater, and for
Но
me it's
должен
also
оговориться по поводу
a
этого
great
мероприятия, что я
acquisition.
не являюсь специалистом по
Just
спортивному праву.
I'd like to specify that,
которая
that I'm
повернута
not
против
an
меня,
expert
она
on the sports
ясно,
law.
совершенно мне об этом напоминает. То есть я, конечно же, не изучал
I
даже
have not
десятой части из того, что
studied
здесь выстроено.
even a
Вот.
tenth
Но какое-то участие
of
в
what
этой теме я
we've
принимал.
discussed
И
today.
действительно, Тамара
But
Викторовна
I
об этом
took part in
упомянула,
some interesting
что
discussions
4
when I
года
was a
назад, если не
judge at the
ошибаюсь, вот в
European
этом
Court.
самом зале было
For example,
замечательное
4 years ago,
мероприятие,
we
которое
held a very interesting
инициировала
event
рабочую
here.
группу Совета
The
Европы,
event
Российской Федерации
was
совместно по
initiated by
созданию
the working group
нового курса, дистанционного курса на
of the
платформе
Council of Europe,
Совета Европы HELP
targeted at
по
creating a
правам и
new
обязательствам в спорте. Сначала он так
course,
назывался,
a
потом
new
стал
training
называться «Права человека
program,
в спорте». От
Human
этого
Rights in
содержание не поменялось.
Sports.
И в этом
The
зале сидел министр спорта Российской
Minister of
Федерации,
Sports
руководство
was
Совета
present
Европы.
here, and
Это
the
было одно из
leadership
самых
of the
таких вот
Council of
замечательных,
Europe. So it was one
совершенно
of the greatest
неполитизированных, экспертных мероприятий,
non-politicized expert
вот,
event,
которое действительно мы совместно
and
организовали
we
с Европейским учебным
held
институтом. И
together
результатом
it with
этого
the
мероприятия
European
1,5 года спустя
Training
довольно быстро
Institute.
стал
So the
новый
result
курс,
was a
дистанционный
new
курс по
online
правам человека в спорте,
program
который является абсолютно
on
доступным.
human
В
rights
всяком
of
случае,
athletes
если я не ошибаюсь,
in
с
sports.
платформы Help нас пока еще
And
никто
we
не
still
снимал.
use
Вот, так
this
что
platform
абсолютно
Help,
теперь
and
бесплатный, да,
this
и
Надеемся, что
online
на площадке Совета
program
Европы права
is
человека будут
absolutely
соблюдаться.
available,
Вот,
and we
к тому же
hope that
платформа
this
открытая, в ней участвуют
platform
многие
would not
государства,
violate
которые
human
не
rights.
являются членами Совета Европы,
It's an
в том
open
числе
platform,
и Россия.
and
В общем,
many
курс переведен на, естественно,
can
русский
have
язык. В
access
первую
to
очередь
it,
он
even
будет
if
сделан
they
сначала на
are not
английском и французском,
participants of
и
some
русский перевод
European
первым.
organizations.
А
So
теперь он переведен на многие
the
другие
training
европейские
program
языки.
was
Это
translated
огромное
into many
достижение, в общем,
languages,
Совета
into
Европы,
Russian,
и
into
этот
the
курс
European language. It's
максимально
a great
востребован
achievement
в
of the
странах Европы
European
и не только.
Council, and
И за
it's
ее
in great
пределами.
demand both in Europe and in other
Кстати,
countries.
я помню, что Сергей Викторович на
And
этой
Sergei
презентации уже
Viktorovich at
выкладывал
that
эту пирамиду, но она была
presentation
в два раза меньше, в два
built
раза ниже.
that
Вот это показывает, что
pyramid,
прогресс идет не только,
and it
так сказать,
shows,
на
but
уровне
it
Совета
was
Европы, но и
twice as
в российской академической науке среди
less
юристов,
tall. And
практиков.
so I think that
Это
the
безусловное
progress,
достижение.
the
Я считаю, что
advances
мы
have been
движемся в
already
правильном
made,
направлении.
and
Теперь,
we are
конечно, встает
moving in
вопрос
the right
имплементации
direction.
всех этих знаний, их
Now
распространения.
We have to disseminate all this knowledge, all this information, and introduce them into practice. So I'd like to say a few words about it in my report. Just a short presentation about the international mechanisms of protection of athletes' rights. The very important idea is a start of my presentation. The justice in all times is a process, and there is no process. If there is no process, there is no justice, fairness. So the procedural justice is the basis of legal redress.
So this principle of fairness, is what brings together sport and law. The principle of fair play is paramount. At the same time, what is perhaps ironic here is that when it comes to settling disputes in sport, fairness and fair process is relatively insignificant compared to other human activities and other spheres of human society. It is clear that athletes are a corporation. We have a lot of such corporations in various spheres of human life that have their own disciplinary procedures. And yet, at the end of this procedures, this kind of result would be subject to the general legal system, the national legal system. However, when it comes to sports, we have a problem at the very first stage. It is not clear where you should launch your appeal, where you should complain. So there is a difficulty in terms of filing certain claims to the court. And this is to a large extent due to what life is like in sports and what sports is like in general. A lot of international officials have told me that settling disputes in sports should be regulated by a body of rules and regulations that do not have to involve or include the principles of fair play, although my colleague Dr. Zaitsev has already said that you cannot be party to a dispute and set the rules at the same time. So these are some very basic fundamental principles that date back to when law itself and sports law also was created. And several guarantees have already been listed, including what Dr. Graham has said. These are some of the fundamental guarantees that are necessary for fair proceedings in terms of anti-doping. And obviously, such guarantees should include the process of competition and the principle of competition. Then there is the presumption of guilt, of the presumption of innocence. Transparency of the proceeding should also be established, and certain very clearly set principles and details that are well known in advance for all the participants of legal proceedings. So failure to observe these principles, I think, leads to arbitrary law in both pre-trial and proceedings themselves. So the question is, how do we fight this arbitrary law, this random application of rules, and what international mechanisms can help to resolve these issues? Well, first off, international justice is by definition the top of the hierarchy in any case, and obviously before you appeal to an international court, you should first address national courts. In other words, when it comes to national proceedings, they cannot be avoided altogether. before you even start talking of international instances and international courts. Now, I think what we should do is identify the violations at a national level. And in particular, I'm talking about those things that are not meeting the standards. And these are the complaints that have been raised by both the athletes themselves and their lawyers. And there is only a small fraction of the cases that are supposed to reach international courts that actually reach them. Most of them stay at the national level. And this is a fact and a sad one, perhaps. There are actually some organizations that are against athletes filing their appeals to international courts because they say that probably the athletes should not waste their time. They need a very quick result and they should not waste the time of their sporting career on filing legal claims. But at the same time, this doesn't mean that all these athletes should stand in line for filing another claim to an international court. But what we should do first is identifying probably the most emblematic cases of arbitrary application of law. And we should insist on applying all the guarantees that I have and principles that I have already mentioned and other participants have already mentioned, including fairness, competition, predictability, and others. Yeah, all those people who advocate clean sport are aware of Claudia Bechstein's case. She is a five-time Olympic champion, and obviously she has a lot of achievements in court, in sports, but also in court. When the court in Switzerland confirmed that there was a violation of principles of arbitration in Lausanne that had earlier confirmed the lady's responsibility and liability for violating anti-doping rules. And what this case has been able to achieve is that Switzerland was confirmed to be the party in charge, and they were able to confirm the applicability of the entire range of guarantees in sports law in the Lausanne Arbitration Court. So Article 6 of this document must be applied, and it was fully complied with. And then the third thing, that immediately after the ruling of the European Court for Human Rights, the court in Lausanne changed the rules of its proceedings. So hence, a question begs itself. When we see just how few athletes actually manage to achieve something like that, we need to ask ourselves, how did she manage to make that breakthrough? Well, first off, she fought as hard in court as she competed as an ice skater, as a speed skater. Obviously, as a German national, she has a very strong, determined character. But other than that, she had a very solid, a very good defense lawyer. And her case was built very well in terms of the defense. And finally, she opted for a very solid strategy because she was referring to the fact that the hearings in Lausanne were not supposed to be public. And that was a very strong argument against the court's ruling. You know, there was also another case of a Romanian footballer, a similar one, who was saying that the court in Lausanne is not unbiased enough, is not objective enough, and that was a very generic claim, and that probably led to the fact that he actually lost that case. So she was more specific in her claims. So if there was anything else that Stein was able to do, she probably should have gone back to the Federal Court of Switzerland and dispute the ruling dating back to 2010. So many people are still unaware why she never did that. I think that was pretty logical and it would have made sense. And Switzerland was expecting that kind of move on her part after the European Court for Human Rights made that ruling. She failed to do that, but in any case, her proceedings continued successfully in Germany, which is her homeland. On the 3rd of June 2022, a federal German court said that that she is entitled to a compensation, an additional compensation for the losses that she has suffered. That is an additional compensation to the money that she is entitled to by the ruling of the European Human Rights Court. So this is a very textbook case, I would say, and a graphic case that shows us how we can enhance the protection of the athletes' rights through international mechanisms and instruments. These international courts are growing in importance when it comes to violations when they are identified and registered in national jurisdictions, first and foremost. And only then they will be referred to international instances. So what we need to do is focus on identifying the cases, the prospective cases from the thousands of cases that we receive. And obviously, national and international courts should coordinate their strategies, even when you have parallel cases in different jurisdictions. Those cases may enhance each other. And some extra things I would like to add is, even though the European Court for Human Rights does not extend its jurisdiction to Russia, still, if Russian athletes and other athletes complain about about actions that were committed in other European states, then those rules may still apply. Now, let me say a few things about the primary investigation into anti-doping violations. It is probably obvious that in order to prevent such violations, you need to work out additional measures. And this is what the European Court, the Council of Europe, excuse me, has been dealing with over the last 3 years, because this was the last European organization that Russia participated in until recently. You know, the situation changed dramatically in spring this year. And in March 2022, Russia withdrew from that organization. But regardless of that, the European Council of Ministers of the Council of Europe issued a very important document. And I believe that we should look at it more carefully. Why? Because, well, Russia contributed a lot to elaborating and drafting that document, and it received an impetus in 2018 when we held the conference of sports ministers in European countries. Then also, this document offers a number of guarantees against arbitrary application of law for athletes who are undergoing anti-doping procedures. And based on what Dr. Graham has said, I can see that this document is very much in line and it complements the one that was suggested by WADA. This document also lays out the rights of athletes as part of the anti-doping procedures. If I understand correctly, this anti-doping act was adopted in 2019, and the recommendation of the Council of Europe Ministerial Council was adopted 2 years later, and it incorporated some of the recommendations and guidelines of the act that Dr. Graham talked about. And now, why do we need to be very focused on this document in Russia? Because Russia is still a member of the Anti-Doping Convention, which was ratified by the Soviet Union back in the days. As you probably know, Russia is, as a legal successor to the Soviet Union, simply took over in terms of that convention. And I'm talking now about the recommendation 2214 of April the 22nd, 2022, about fair principles of anti-doping procedures. And the recommendation, the document focuses on ensuring fairness for pre-judicial, pre-court anti-doping procedures. First and foremost, it suggests that there should be a fair procedure before the court, and then several more pages list the principles of transparency, predictability, effective protection of athletes against allegations, and other principles. So obviously the drafters of this code clearly realized that the situation in sport leaves a lot of room for improvement, and it is a far cry from these rules being implemented and observed. At the very beginning of the discussion, we did mention that fair proceedings should be there in sports. I think we have a consensus about that. But the next question is, how do we do that? And that document provides very clear instructions and guidelines on how to do that. And this document calls on the states parties to take those principles into consideration and facilitate their implementation and translation into life. So this document is a major example of international cooperation in terms of fighting a random and arbitrary application of law against athletes. This kind of international document may well be used in any kind of legal work. And this text to me is like a little bit of sunshine in cold water. This cold water continues to engulf the European legal space, and it is further fueled by anti-Russian political rhetoric. And you know that Russia continues to fight doping in in the framework of various instruments and mechanisms. And even though there are some certain states that are trying to squeeze and supplant Russia out of those mechanisms, but still, we persevere. And in early January 2022, I have to disagree here with Dr. Shashihina. There are some cases that are being regarded now within the European Council for Human Rights. The question is if they are being considered indeed right now. Now let's hope for the best. So that document has been released on the website in French and English. And that is a document that brings together the judiciary, the legal practices of the European Court on Human Rights. And it's an important document because other courts like the Lausanne Arbitration Court will be able to refer to that document in its rulings. The other publication that is available on the website is a book by Daniel Rettaker, who is a well-known lawyer who works with the European Council for Human Rights, who repeatedly has come to MGIMO and MGIMO University and participated in our discussions on sports law. So he has published a book that is advertised as a textbook in human rights and sports law and proceedings in sports law, including the European Court for Human Rights. The book has been published in both English and French. I hope it will soon be delivered to Russia, and we will be able to translate it and maybe publish it in Russia as well.
Anyway, it can be used in our work to promote clean sports. Just a very important contribution to achieve clean sports. So we are continuing our involvement. Thank you very much for your attention and for your invitation. Thank you, Mikhail Borisovich. I just really meant that there have been cases, but there have been no rulings on them. So they are being considered and heard, but rulings are not taken. That was my point. And now we'll see. Thank you for mentioning the book of our great friend Rigete. There is a page of gratitudes in this book addressed to Mikhail Lobov and to our colleague who took part in developing this courses training program, to Zakharova. So there are representatives of the Russian School of Sports Athletes Law for their contribution into the publication of this book. Thank you very much, Mikhail. We hope that athletes' rights wouldn't have to be protected because they would not be violated. But in any case, as practice shows that when the rights are breached, athletes should be represented at an adequate level in all court instances where the presence of a professional lawyer is a must. Now I'd like to give floor to my favorite person, to my colleague. It's a person respected and valued by our community and by athletes and by Olympic winners. I am talking about Anna Vladimirovna Kuzmenko, partner of the law firm Schellenberg-Whitmer. She has created a unique practice of athletes' rights protection in Lausanne. So, Anna Vladimirovna, are you with us? The floor is yours. Thank you very much. Can you hear me? Yes, we can hear you. We can see you as well. Thank you for your really very kind words of introduction. For me, it's a great honor to be here with us at this forum where I discuss so topical and relevant issues, and a great moderation by Tamara. All these things are very useful. So my topic I'd like to talk about is the protection of athletes' rights, relevant issues and trends. So what are the rights guaranteed at a national level, including by the Convention of Human Rights Protection? So it would be a logical continuation of the topic discussed by our previous speaker, Mikhail Lobov. I'd like to stress once again that the complaints filed can be filed by Russian athletes into the European court. This topic, human rights protection, is becoming more relevant, and it attracts more and more attention. For example, 10 years it was not that topical, but now it's one of the priorities. There are a lot of publications on the topic, a lot of fora held to discuss this topic, and it will become more and more relevant. And especially it's relevant for Russian athletes. As we know that lately, for various reasons, the rights of Russian athletes have been violated for some groundless reasons. Unfortunately, it has led to undermining many sports careers. So I'd like to start with the topic Mikhail has already talked about, the right of an athlete to fair justice. So, and fair consideration, case consideration by court. It's of great interest for me. Lately, I've had many questions addressed to the cases considered heard by consideration, federation and CAS, whether their hearings are fair. And this right is reflected, set forth in the European Convention on Human Rights. And it's aimed at providing for integrity of sports and its cleanness and the athletes' rights to fair justice. And of course, we should have a balance here. There, we mean such fundamental rights as to be heard, due process, the equality of parties in the process. All these issues arise in our daily practice. If I compare these procedures with other processes, and I have a number of questions relating to the processes on athletes' rights. So whether the principles of human rights are applied during the arbitration court hearings, and the case, an emblematic case is a case of Claudia Bernstein. That's justice, fair justice that should be provided by the state, while CAS is a particular justice. It's not justice provided by the state. So it's just some private part of justice. And the case of Claudia Bernstein established that, yes, the guarantees of Article 6 should be applied to any court hearing, to the arbitration hearing, with regards to its mandatory nature. The sports arbitration is different from the commercial arbitration in the following way. The parties in the commercial arbitration can come to an agreement to make a deal. And here, in sports, there is mandatory consent or mandatory arbitration. If you want to be a professional athlete, you have to agree to arbitration clause contained in the respective rules. And so it's just a specific nature of mandatory arbitration of the arbitration courts. And that's why, because of this, the European Court has come to a decision that the standards of Article 6 should be applied, that they cannot just leave behind them. Because an athlete doesn't have a choice where to apply to arbitration. It means take it or leave it. If you want to continue your career, you have to accept all these rules. And though the decisions with regards to Bernstein's case refers the Article 6, then the question arises whether other articles are applied. And that gave rise to debates whether other standards are applied, or do we apply only Article 6? My personal opinion is the following. According to the analogy, of course, other standards and articles should be applied as well, those that are provided for, guaranteed by the convention. And this decision has been treated with great consideration and seriousness. And the right to public hearing is also a very important right, and CAS made amendments into its code in order to avoid future problems, just to avoid the missile in its orbit. So there would be no problems with public hearing. And this provision was applied by athletes. There were public hearings in CAS. And there is a number of restrictions we've mentioned. For example, when the public hearings are allowed and when they are not allowed. And the important conclusion is, and CAS draws attention to it and implements it into its practice, that it looks after the decisions taken by the European Court of Human Rights. It's not just empty words, they really follow the decisions. And recently I took part in a conference and they just stressed that the CAS judge stressed that they looked after the the European Court for Human Rights decisions. Another other important issues I'd like to talk about is independence, impartiality, and how to provide these two principles, how to guarantee the implementation of these two principles. Unfortunately, I am a little bit disappointed in this because the European Court, the athlete said that CAS is not impartial and independent enough in the part of making rulings and decisions. And the European Court did not agree with her assertion, but a positive moment was that judges by Cyprus and Switzerland had a special opinion. And here we can talk about two aspects. Why this issue about impartiality and independence arises. First of all, the judges, the arbiters are selected from closed lists. These lists are compiled by a special commission, and there is no sufficient transparency that shows the process, how the process of selection and why these particular persons are selected, who puts forward their candidatures. So it's just a closed list of judges, arbiters, with no transparency of selection. And the court judiciary practice shows that there is no problem with the list. It does not affect impartiality and independence because it's a very broad list. It includes just several hundreds of experts, and the parties have enough room to choose, to select the best candidates. So there are about 300 persons contained in the list. But recently, when the anti-doping department of CAS was set up, the judges for this unit are not selected from this broad list. but from a very limited list. And so there are only 23 persons included into this anti-doping list. So if it's one arbiter hears the case, the list is even smaller. There are only 21 persons in the list. So maybe when this case is regarded, heard by the European Court, someone will put to doubt the impartiality of the hearings, which is based on this limited number of members in a list. If we have a broad list, it's okay, but if it's limited and includes only 21, 23 persons, we cannot speak about a broad selection. So the first point is the untransparency and limited number of cars. Another important issue is the chairmanship, how the chairman or president is appointed, or a single arbiter. Again, there is a lack of transparency for the parties. How this person is selected, who selects it, for what reasons. All these issues are not clear and not transparent, and there have always been questions towards CAS, whether it's really independent from the international federations. It is really independent, but how, whether it's as independent as in the first case when it selects its chairman, and the decision of Claudia Benson didn't give an answer to the second question. They didn't give any comments on it. So it's just a question that requires discussion. And two judges, arbiters with special opinions have a consensus. They have a consensual conclusion that the influence of guiding bodies gives rise to concerns. It can be quite, this influence can be quite considerable. So it's a very interesting fact that these judges issued a special opinion. So we'll see how this practice with regards to CAS will develop with regards to the selection of arbiters, judges, especially what relates in relation to this limited list. And this topic has been discussed by the professional community, which has come up with some recommendations that should be taken into account to avoid potential violations of a principle of impartiality and independence of the tribunal of the CAS. For example, the commissions that appoint the arbiters, the judges, the more diverse. They should include representatives of different groups. They should be accountable how they select judges. This information should be more transparent and public. If these lists are updated, this information also should be presented to the public. And another recommendation was made with regards to the following. The chairman should be selected not by the court, by two arbiters, lateral arbiters. If they do not come to an agreement, then it should be appointed by the arbitration court. So this question is still open. It's still on the agenda. So it's very interesting to see how it will be tackled, given the specific opinions by two judges. So we'll see how the situation will develop. Also, I'd like to touch upon the following with regards to impartiality and independence. The investigation or hearing consideration of a case on a stage before the case is heard in CAS. So how all these recommendations will be implemented into practice. So I believe that we should put in place a mechanism because at present there are many questions with regards to if there are these limited lists with 21, 23 persons. The CAS answer was we have made a lot of progress. In the past, the Federation heard the case. Nobody selected a list of possible judges. And now it's a big progress. You can select among these 21, 23 persons.
Why I'm talking about this? There are indeed some issues at the level of the tribunals, and you see that they are part of the structure of the federation. Again, we come back to the same issue of who is the prosecutor and who is the judge. Isn't that the same structure in the first place? So we have issues of due process emerging here. I can cite some examples from my own practice. When we looked at cases of Sochi Olympic athletes, and there was a committee established by the IOC, and very often, whenever we looked at cases, evidence of and proof of the athlete's guilt were filed, for instance, just one day before the hearing. And you see those texts have like hundreds of pages, and you need to look at the allegations, at the claims, and you only have a few minutes to look through it at the hearing itself. So there is an imbalance between the sides in court in terms of representation and in terms of how well each of the sides is prepared for the proceedings. So it would be very nice to implement the principles enshrined in recommendations that were discussed earlier today. One more thing that I would like to highlight when I was talking about recommendations and guidelines on how to make the process more transparent when it comes to designating and appointing the judges, let's refer to the Convention on Human Rights, and in particular Article 10. And I'm talking about the right and the access to information. I think that this is a question that is worth raising. Can we actually say that having zero information on the composition of the Court of Arbitration actually constitutes a breach of Article 10? I think this is another important issue that will further be regarded by sports lawyers. The last thing I would like to talk about, last but not the least, is discrimination. Article 14 of the Convention is about non-discrimination. I think this issue is growing in relevance, and you can have discrimination based on race, gender, and nationality, and excluding a group of athletes from competition. Does this constitute discrimination? Can this principle indeed be applied in CAS? Can you refer to it? Should the Court of Arbitration take it into consideration? And it is followed by a whole number of principles which are recognized in international law and human rights. These include the principle of presumption of innocence. collective penalties, collective punishment, and the question of when you look at the sanctions against each individual athlete, and once their guilt has been proven, can those penalties be indeed imposed? So there is the principle of individual responsibility. I think I've been talking for quite a while now, so let me wrap my presentation up, and also please allow me to draw a couple of conclusions on applicability and how those principles of human rights are applied in CAS. So one increasingly growing trend is how these arguments are indeed put forward very often in the proceedings, but most judges in CAS are not specialists in human rights. Most of those judges specialize in sports law, but none of them, or almost none of them, is a specialist or an expert in human rights. So in the case WADA versus RUSADA, there were hundreds of pages of expert reports in terms of human rights violations, but the arbitration court only covered human rights in a few paragraphs. And then this is something that the situation that repeats itself very often. Now let's talk about the Supreme Court of Switzerland. There is a very limited scope of review for the Swiss Supreme Court on whether it should abrogate, whether it should renounce that decision, denounce that ruling or not, in terms of human rights, because in terms of its competence, it mostly does not cover human rights altogether. That is to say, the only thing that the athletes can do here is go to the European Court for Human Rights, and then in Article 14 says that the athletes should be provided with adequate legal protection. And then you see that in other courts, such as the Federal Court or the Supreme Court of Switzerland, these issues are ignored. So essentially, we can say that cases of violation of this article are widespread. So the only thing we have to refer to is probably the positive practice of the European Court for Human Rights, and let's see at the further precedents that are going to probably improve the situation. Thank you very much for your attention. Yes, indeed. When it comes to the list of the judges, it is indeed a big issue, and one of those issues is that on the list of the judges, we do not have any Russians. Why is that still the case? I don't know. But I have repeatedly raised it at various levels. And I even talked to the senators in the Council of Federation and Russian Parliament, because today the lack of experts in the legal community among the CAS judges is a big problem. I'm pretty sure that we do have such lawyers, and we have very good candidates that could probably make it to CAS, to the list of the judges. And again, I'm pretty sure that at various international platforms, they could probably use their experience, and they could be included on that list. Now, when it comes to the issue of human rights that you have raised, well, they have been extensively covered in CAS when one of the judges who joined it was Jean-Paul Costa, who was formerly deputy president for the European Court for Human Rights, and he so to speak, took that topic to the platform of CAS, and he has been extensively talking about human rights references and human rights violations. But indeed, that might be insufficient, and probably judges of CAS should probably have some training courses or upskilling courses so that they can understand a little bit better what human rights are like. Yes, probably MGIMO University should come up with a course like that. We have a lot of experience in terms of defending and protecting human rights. Thank you very much, Anna. And this has been a wonderful presentation. Thank you for your support, for always attending our academic platform, which is a great place for all the parties to any dispute and all the stakeholders to be involved in exchange of opinions, because we build our common future together. I'd also like to give the floor now to Deputy Head of the Legal Department of the Olympic Committee of Russia, and he's the Secretary General for the National Center of Sports Arbitration. Mr. Artem Koshev, thank you very much for attending the discussion and participating in it today. Indeed, we have a national center like that, but probably not a lot of cases are considered in that center. But again, perhaps statistics are going to improve. The center has been undergoing a lot of changes. Recently, rector of the Moscow State Legal Academy, together with GIMO University rector, have been talking about the activities of this center, and they said that the center now also covers labor relations and related issues. So would you please be so kind as to share this joint project that we carry out? Thank you very much, Dr. Shashikhina was very attentively following all of the participants' reports, and I was actually making notes because there are some things that have to do with our court. We have a Russian law on physical education and sports, and that there is a provision that says that there should be a pre-court proceeding and a different procedure for disputes in federations and sports leagues. Then a further instance would be CAS or BAT for basketball. For us, I'm talking about national arbitration courts. Indeed, there is an issue of considering and looking at disputes in sports. So one of my colleagues here has a long, Dr. Alexeyev, he has a long list of literature that has to do with the rules of procedure. Well, let's look at football, for instance. If labor rights of any footballer are violated, then we have an opportunity to reinstate that person in their club. But then according to other documents, a footballer is entitled to receive a compensation before the end of the contract, and then they may transfer to another club. So the question arises, if this kind of dispute is handed over to, is submitted to our court, are we going to apply the practice and the precedents that are already there in the sports law, or are we going to look at the labor code of Russia? So this is a collision of sorts. What should the clubs do? This generates a chaos. And I believe that given this dual nature of legal regulation, when we have rules of procedure in sports on the one hand and official laws by the government on the other hand, we need to work out a different procedure. For instance, we have a fast-track proceeding of 24 hours for an athlete at Olympic Games and other contests, when tournaments, when we have an ad hoc division that will look at hockey disputes, for instance. But we do not we do not review a lot of the disputes because we've only been around for a while. But most of the anti-doping issues that we look at have to do with football. And labor relations and labor disputes can actually be looked at by an arbitration court. And the state, however, does take into consideration the emerging trend that it's trying to implement the existing system into national legislation. I think it's a great thing. There are a lot of issues related to the proceedings themselves. And I remember Dr. Zaitsev saying that the athletes can actually dispute the competence of the court and its jurisdiction. Yes, we do have an issue like that, but according to law, a dispute of an arbitration dispute can be reviewed by an arbitration court as long as there is an arbitration agreement. But there is also an arbitration reservation in anti-doping rules, and it says that a dispute involving national athletes can be from the same country, can be referred to our center for arbitration. Now, when it comes to statistical data, now we have around 14 cases. A number of them are under consideration, others are pending. I'm talking about anti-doping cases specifically. So a court of arbitration reviews cases de novo, and our composition as a court is an open procedure, so each side may select their own representatives, and we also pay a lot of attention to, we make sure that the judges are fair, and we have what we have traffic lights principles. That is to say, we have green light when they may review the case. You have yellow light when there are some issues, some reservations, and red light when the composition, when the judges cannot review the case. Now, there are some other issues. For instance, an athlete has violated anti-doping rules, and we need to enforce certain consequences. For instance, he's supposed to be stripped of his awards and prizes. Should that be discussed in a court of arbitration or no? This is debatable. Then there is another issue. I think this is pertaining to all courts. What about the judges of the arbitration court themselves? For instance, they might identify the lack of certain documents or that additional circumstances have been established, but the sides have not submitted any such documents. So should they request those documents? In other words, should they be proactive? So indeed, this is also a very debatable issue. So we try to ensure a maximum transparency, but we are limited by the law on arbitration, and we have started publishing our rulings on anti-doping cases as well on our website. It's clear that we do make some exceptions and exemptions, but still you can review those documents. And then the sides can also, in our court, the parties may use some other judges who are not on the list. In this way, we are ahead of CAS. Most important thing is that they have enough professional experience, that they are objective and unbiased and independent enough. Now, when it comes to arbitration in sports, yes, indeed, I'm pretty sure that we need to have this institution. There should be a stress test of sorts if there are any guidelines coming from the European Court of Human Rights, we need to take that into consideration. But this is a living mechanism, a living body, and there is always room for improvement. Thank you very much. I believe that we can ask the Association of Lawyers in Russia and the Committee on Sports Law to organize a round table, because you see this is a very big issue of being able to select a judge who is not on the list, but someone who is simply a respectable professional. Now, this might be a tricky thing because this may generate certain problems. But in any case, your court or the Center, National Center for Sports Arbitration, even though it has been only around for a little while, it has indeed been very effective in several cases, and I think we should exchange our experience and the best practices that the center already has. Thank you very much, and I would like to give the floor further to our colleagues who represent our partner academy. And this is going to be Dr. Alexander Orlov, who is associate professor at the Department of Sports Law in the Moscow State Academy of Law. As I have already said, Russian and Belarusian or Belarusian athletes are very often banned from international tournaments, and of course, our federations and respective ministries and agencies are trying to organize additional tournaments. I would not call that alternative tournaments because there is no alternative to the Olympic movements, but we are trying to keep the athletes in the sports that they love. And we also have Grand Prix stages. We are looking at the opportunity to join Asian sports and leagues, and obviously this issue is totally under the supervision of the Russian government. We do understand that sports careers are usually not very long, and yet the athletes have to perform to produce top results.
And the most important issue is that our athletes are really well prepared, well trained, and they should take part in high-level competitions because they are the best. Unfortunately, our federations just lower the dignity of our athletes. So non-participation of our athletes is a big issue. So, Alexander Alexandrovich, what is the stage of the discussion with regards to the sports events? Okay, actually, I'll be brief, and I'm going to talk about violations in the past and what should we expect in the future. So there are three violations, or three issues: monopoly of federations, anti-doping regulation, and the sports events. So I'd like to talk about the first block, the monopoly situation. If the athlete does not train, his level is falling. So we have to keep up the sports activities to preserve, to retain a high level of athlete. So we just have to think about some corporate teams, for example, post office team, but whether it's included in a single calendar plan. If it's an official level, there are many obligations arising from this approach. And if they such corporations, for example, Post Office of Russia conducts such, organizes such events, they may also be subject to sanctions. Nevertheless, the rules will change. For example, if the international federations confirms the rule that 6 boats should take part in the racing competition, we will change the rules. For example, there will be only 5 boats and the distance will be, instead of 600 meters, will be 500 meters. So at present, the international federations are in a monopoly to set the rules for international competitions. But the rules are rather broad. They are not very specific. So what do we mean sanctioning? It's just tacit agreement or affiliated persons. Who are these affiliated persons with regards to the international federation? So it's not always clear. While sanctions at present is the life suspension or expulsion from the federation. And the International Swimming Federation says that they are the only body in the world in terms of setting the plan for competitions. And there is a prohibition for affiliated persons to interact with non-affiliated persons, for example, with Gazprom, if Gazprom will organize its corporate events and it's set up its corporate team. So Gazprom would be automatically subject to sanctions. So can it be qualified as a direct violation? It can. There might be indirect violations. For example, federations have to support the efforts made by national federations. But if the national federation supports the effort of some corporate players, that means that they do not support the activities of the international federation. So there might be very different interpretations here in this regard. And the general issue is not what Russia does, but what it does not do. For example, why it doesn't prevent the alternative event. In this way, it will discredit a certain sport. And so there are restrictions of this kind in all charters of various sports, in gymnastics, badminton. For example, the International Federation of Badminton says that the sportsmen, athletes cannot take part in any alternative events, and national federations has to look after it. Or the penalties, the sanctions are lifelong disqualification. So the question arises whether we have such developments in international practice. Yes, for example, when they try to set up a skating event, the sanctions were imposed and those organizers were suspended for life. So there are many other examples like this. We are not the first one. For example, some national federations even had to introduce changes into their charters so not to disqualify the clubs and so that they should not be subject to sanctions. Another example is an attempt in Europe to set up a football league, and UEFA again introduced sanctions, and athletes, golf athletes, were suspended. Another aspect is the position of the European Court. The position has been changing. The last precedent, though it would not be the last, because there is consideration of case on golf. So the European Court recognized that there were some violations of the rules of golf players, and the case is being considered. Before, the approach was a different one. The monopoly was not subject to any disputes before. You mean the court, the European Court? Yes, the European Court allowed to challenge these rules, but actually the standard of proof should be so high that it was really impossible in practice. And now, and if we talk about doping control, the athlete has to follow the rules and not try to avoid tests. And so now we have to do the following, just to define what we mean by the new formats of events, then to identify new kinds of sports, because there are sports that do not are not regulated by international federations. Why do we need to do it now? Because lawyers can develop the law quicker, and athletes would train in other fields, will have time to change their specialization. Yes, it's a very good message in conclusion of your presentation. These two processes are interconnected, and it's not possible in terms of law to think about these issues, because we have to introduce changes into the process, and the headquarters and federations have to fit into the process, because they have to be ahead of the work done by the lawyers. And in conclusion, I'd like to give floor to our colleagues and our neighbors. The director of the Center of Legal Support of Innovational Interstate Relations of the Russian Academy of Russian Economy. We are allocated just nearby, and we always greet our neighbors. So the floor is to Ilya Ushankov. And the topic is also very important: new legal reality, extraterritoriality of criminal law in counteracting doping, or the legal phenomenon of the Rodchenkov's law. So yes, the topic is very attractive. So okay, so we are still debating an issue whether the sport is politicized. Yes, of course, everybody knows about Grigory Rodchenkov and what was the basis of his position. So extraterritoriality of criminal law is just an impossible legal construction if the situation is normal, it's impossible to apply it because there is a presumption of innocence. It's not a criminal law. It's not a criminal process. Whether it's a civil process, it's not a civil process, it's not a criminal process, it's quasi-criminal process, which is focused on prosecution and on accusation. So Rodchenkov law has good intentions that pave the way to hell. So we're fighting for fair play, for fair justice, but in reality we just undermine the most important legal principles. And so the core, the essence of this law, which has been implied recently, by the way, with regards to the Nigerian athlete. So what will happen to our Kamila Valieva? By the way, we don't know the case of Kamila Valieva. It's a case of a protected person. And those who permit themselves to violate, and it relates to sports instances, to WATA, to International Olympic Committee, and to other bodies, they themselves violate their own codes, and we just would like to recommend them not to do it because they violate their codes and then they blame our athletes. And I hope that everything will be okay with our athlete because she's a brilliant athlete and will show brilliant results. Yes, I agree with you. So this Rodchenkov's law is, by the way, targets the experts who are nearby the athletes, who somehow facilitate the prohibited substances usage. And the United States is always involved in it. It's the country number one in terms of medals won. So the values are distorted in sports. And so these principles, values, contestable character, adversarial character, public hearing, transparency, all these aspects are being undermined. And these issues have been studied studied in the past by our law school, and the study shows that the United States is a unique country in terms of extending their jurisdiction with regards to sports, environment, human rights protection, and there is a doctrine related to doing damage or harm to the interests of this country, of the United States, no matter where this action takes place. If the harm is done to the United States in any point of the planet, this law is applied. And in conclusion, another very important point. One of the authors who has discussed this law has drawn the attention to the fact of retrospective application, retroactive application of legal towards for legal relations. So the position of the actors, those who take part in competition, are at the moment of tests, because before, in the past, there were no methods of testing like this. So should we use limitations with regards to the law, whether this procedure will remain transparent and will provide proof and evidence, because these methods related to testing have been considerably improved. So wrapping up, I'd like to say that sports today is just the activity that brings together all the countries and continents, and we should not allow it to lose its independence. Thank you very much. You've touched upon a very important issue, the gaps in law, in anti-doping code, and in legal regulations. The protected person. There is a paradox that on the one hand, a protected person is a suspect, and on the other hand, it's a victim at the same time. So these gaps were the focus of the attention of the arbitration court. And we had a response from WADA and the International Olympic Committee that they are not disappointed in the CAS decision taken in February 2022 by the ad hoc panel of judges. So for me, it's difficult to just to perceive that the body was created by the international bodies, and they write that, or their responses that they are disappointed. That means that it's the athlete, an athlete is not to blame, because a new protective measure cannot bring about new threats. And of course, this protective measure was needed because it's an athlete, a minor, and it should be included into the category of a protected person. And also, I'd like to draw attention to the violations made by the authors of the international documents and instruments that should be followed by all athletes.
And this principle is keeping a secret to the personal data of any athlete, because as one of my colleagues said today about the case of Spickstein, the speed skater, you know, we can only have an open process, a public proceeding, as long as it is stipulated by international agreements, in particular the convention. But very often the proceedings cannot be public. They need to be hidden by the public eye. And again, this idea was not designed or devised by Russia. This is part of the general principles that were laid out and established by the European Court for Human Rights. So if we are to talk about international instruments and sports disputes at the international level, I think we should suggest to those international organizations that they revise and review the documents that they drafted themselves. And going back to the case of the protected person, in January 2022, there was another case involving a Russian protected person. Has anyone heard anything about that? I doubt that. The information came out about that a week or two ago, and that's a Russian athlete who was involved in that case, but most people do not care about that because this information is not sensationalist. And I would like to stress here that the Russian medal that was actually awarded is obviously disputed and complained about by the American national team. They are complaining about things that are beyond their competence and their jurisdiction. So what I believe they should do is study the legislation and their own legislation and international legislation too a little bit better, and think before they actually speak in public. They should study information better first. Very often, American media would publish certain information because before it was actually released, a few minutes before that, and that information was also spread in various social media. And let me remind you that these are legally binding documents, even for the United States itself. Okay, so the presentations are over for today. I feel like we have exceeded the time limit slightly, but I did tell Madam Loginova that it would not be possible to discuss all the issues within 2 hours. As a moderator, I wanted to invite all the parties, all the stakeholders, because otherwise I don't feel like it would be an objective discussion. Such round tables are exactly supposed to be doing just that. They're supposed to highlight the gaps and the sore points and the challenges that we have in all sorts of proceedings on sports law. For this session, I requested this particular room, so that's why I didn't encourage you to speed up your presentations. And I would like to say that posing a question is a first step to solve those questions. So we have a little bit of time now to ask some questions to one another. Yes, please. Good afternoon. Could you speak up, please? My name is Vasily Kluyev. I am a student of sports management program, and I can see that sports lawyers who are still in this room are probably the strongest ones because they stayed until the end of the discussion. Together with my fellow athletes, we are planning to build a sports diplomatic platform, and we do need assistance from professional lawyers. And like Alexander Orlov said, a very good way to work on it is a proactive one. So we have mixed martial arts on this platform, and I believe this would be would make for some great news to be released. And we will be able to advance a little bit further, and we will be able to promote athletes through that platform. And the idea of this platform is that we will be able to move forward with your assistance as legal experts. The plan that we have in mind is to hold an international conference and discuss the detail further at that conference. Thank you so much. We are always open to accept all and to look at all kinds of proposals, and probably you should file that proposal to our committee, because everyone who has to do with the sports world, we are all part of the Committee on Sports Law of the Russian Lawyers Association. So if you need a lawyer, I think this is the best place to go to. Thank you so much. Are there any further questions from the audience? Or maybe comments for that matter? Yes, please. Dr. Shashikhina, dear speakers, by the end of the second day of this forum, I'd like to address you as friends. And I am from Krasnoyarsk. I'm from the CSP organization, a deputy director and also a sports lawyer. And I'd like to thank you for raising here one of the most acute issues for sports lawyers. I'm talking specifically about considering various disputes in sports arbitration courts and other courts. For instance, if there was a case when certain harm was done to a child's health and that child was involved in winter sports. At the third session of the court, the judge was very close to degenerating into an emotional hysteria. And the judge was saying that we are trying to apply the wrong rules. And unfortunately, the problem is that just too many judges at district levels do not understand that sports is built upon consensus and voluntary accord. Any sport whatsoever can only grow thanks to and through signing certain documents that we all are supposed to stick to. And all the issues that were raised here today are very, very relevant. Even this Rodchenkov law, this Rodchenkov Act that was mentioned, is also a major issue for us. Thank you very much for this enlightening roundtable and discussion. Thank you too for your feedback. Thank you for coming here all the way from Krasnoyarsk. We are always happy to see you at all the events that we carry out, as well as our colleagues from around Russia. Any more questions? As long as there are no further questions, because the second day of our work is drawing to a close, and this is also the final day of the forum. You know that RUSADA was not planning a closing ceremony together as a plenary session. We decided we would draw our own conclusions at every session that we have. The people who actually left this room are actually moving to another roundtable or another event, also part of the forum. So probably this is my fault as a moderator, that I could not stick to a 2-hour limit, but because you see we have very rarely such great meetings, and the forum itself is also held very rarely. I thought I would not limit everyone in terms of their presentations. And I believe that the forum has been very successful. Maybe as a host of this forum, I would say that the discussions, the meetings, and the issues that are the most burning issues for us today, they have indeed been raised, they have been addressed, and there were no attempts to somehow disguise or distort the essence of these issues. Sports provides here an open platform for people to interact, and our forum is an open platform for us to talk about sports. As long as Russia is making progress in terms of sports, and we can see that from the reports of the federations, and the Russian athletes are doing very well, and they earn the medals, but it's all fine, but we should be here proactive, and we should take a preemptive or preventive approach even. Just we should think of issues, of how to tackle those issues before they pop up. And together with sports lawyers, with the teams, the coaches, the federations, and the lawyers, the medical professionals, we should come together and discuss what is at stake, because otherwise we will always be in a situation where we have, so to speak, to put out the fire when it has already started burning, but we should prevent the fire instead. Thank you very much for taking part and contributing to our forum. We had limited time to organize it. We only received a proposal to do that a few weeks ago, but still we managed to gather a team of like-minded people, sports enthusiasts, people who are crazy about sports in a good way, and in particular people who who are Russian sports enthusiasts and people who advocate a great place for Russian sports in the international community, and those who will always protect the interests of Russian athletes. Today is the second day of December, and very soon 2022 is going to be over. In a few weeks, it's the new year. So I would like to wish you to leave all the pain and sorrows behind in the year 22, so that next year would bring many new wonderful friends, and for us to continue sticking together, promoting the interests of Russia and supporting one another. Thank you very much. MGIMO University is always happy to welcome you, and we love participating in your events too. Thank you so much. And obviously, I would like to thank the interpreters who made it possible for our colleague to participate in this discussion online. He doesn't speak Russian, even though he has been working with RUSADA for a while, and a big thank you goes to the technician. Thank you so much.